good morning. Is that working?
Yep, we can hear you.
Good morning, everyone, in person and online. Thank you for coming along today, this morning. My name is Jackie Gould. I'm a Senior Research Fellow here at the Northern Institute, the format. So I think Lani is going to help out with some IT in the background there. She's going to keep an eye on the chats and the Q&A. And Lani, is that right? And I think
we'll take questions at the end.
Yeah, we'll take questions at the end. So there is probably going to be more people online than in the room today. So if you want to chuck questions into the Q&A box, Lani will keep track of those and she'll make sure that they're read out at the end. Yeah, any other housekeeping? Good, awesome. All right, welcome everyone. My name is Jackie Gould. I'm a Senior Research Fellow here at the Northern Institute. And today I'm going to be talking about Sea Country. So that is the law that derives from First Nations systems of governance, as well as those which derive from Western systems and which operate specifically here in the Northern Territory. Now, not all systems of law are the same. First Nations systems of law are the same, and in fact, there's a great deal of diversity along the Northern Territory coastline. And similarly, historical, geographic and other factors mean that there are different situations faced across the coast in terms of how legislative processes play out. So today I'm going to speak specifically to the story of Marra Sea Country in the Gulf of Carpentaria. But where possible, I'll attempt to illustrate some basic principles that are applicable in a wider territory setting. Awesome. Okay, so before I go any further, I'd just like to acknowledge that today I'm presenting from Marra Country, and I'd like to recognise Larrakia elders past and present. I'd also like to show my gratitude for being able to work and live on beautiful I'd also like to acknowledge and thank Marra elders, past and present. It's their hard work to protect Marra country and culture that creates the foundations for the work we're speaking about today. And I'd like to acknowledge my colleagues, Sean Evans and David Barrett, who are both Marra men, the Yarra Sea Rangers, and co-researchers to this project. Unfortunately, they're not able to be here today, and so that's why, in part, we've chosen to focus this session a little bit more on the impacts of Western law as much as a detailed discussion of Marra law itself, which I'd rather do when they're here to speak to that themselves. So first, I'm going to give a brief outline of the work that David, Sean and myself have been collaborating on. Next, I'll introduce Marra Sea Country, and I'll talk a little bit about its history, its identity and the law that it speaks. I'll then move on to a discussion of legislation, which today reaches out to create another governance layer over Marra Sea Country, before coming back to some of the challenges and opportunities that this creates for Marra, as well as other First Nations saltwater people in the Northern Territory. So that's what you're in for. Before I go on, I'll just flag a couple of caveats. So first of all, I'm a non-Indigenous researcher. I have a background in anthropology. So I'm not a Marra law expert. I will follow the obligations to ensure that come from being bestowed with teaching about country, which includes an obligation to help ensure that that law continues. As a researcher, I interpret this obligation to include supporting others to understand these place-based prescriptions so that collectively we can also address our own governance and the harm it sometimes causes to country. That said, I will keep my discussion to a general level, reflecting the boundaries and the knowledge that I can speak to, and out of respect for those things I will never fully understand, nor am I entitled to know about. Similarly, when I turn to a discussion of Western law, I ask you to bear in mind that I'm not a lawyer. I'm a researcher, so I have a strong grasp of legal policy and administrative settings that are in relation to the legislation that impacts on sea country, but there are definitely limits to what I've managed to cobble together. So I'll try and be clear when I am unsure about a particular legal detail. And in the audience, in person and online, perhaps, there are people who are subject matter experts in some of this stuff, so please feel free to jump up and interrupt me or add comments at the end if I've missed anything. And finally, I'd like to flag that the complexities I'm about to raise are not critiques of any agency or any piece of legislation. These are really long-term issues that have detailed histories, and there are really complex reasons why, which inform how each of these statutory frameworks operates. And I really don't have time to do justice to all of that today. Only trying to sort of illustrate the way that Aboriginal people sometimes get positioned within this complexity. and how they try and grapple with it. Okay, so the project. A couple of years ago, we were lucky enough to secure an AIC linkage grant to look at issues around a range of issues to do with Indigenous-led sea country management. Partners to the linkage project included Parks Australia and the Parks and Wildlife Commission of the Northern Territory. So these are the Commonwealth and Northern Territory departments who administer marine parks in their respective jurisdictions. Both were interested in the element of the AIC governance and understanding what best practice collaborations with First Nations groups in a contemporary marine park setting might look like. There is both a Commonwealth and a Northern Territory marine park in Marra Country, so it made sense for this to be the geographic focus of the work. As I embarked on the process of co-design, I wanted to know what my Marra collaborators, as well as my government partners, wanted to focus on. It became quickly evident that Marra faced many challenges when it comes to enacting their contemporary duties to care for sea country. I was quickly flooded by stories about sacred sites intrusions, about the impacts of discarded fishing gear, about illegal access to those areas that Marra hold title under Western law to, and alienation from those areas that they don't. Amongst the onion layers of system failures and harm to country, how would we make sense of it all and come up with some pathways forward? Well, what we had to work with was a couple of very clever and committed Marra men in Sean and David, a supportive ranger group in the Yarra, and some genuine government partners who were willing to have uncomfortable conversations. So what we decided to do was focus on the following work. First, we would talk to all the Marra families to do a robust assessment of why Marra Sea Country is important. It wasn't to be a thematic assessment, it was to be spatially explicit. Country is made up of real places with real meaning. So we wanted to know where those places were and what those meanings were and what was involved in keeping each of those places healthy. The idea was to develop a Marra designed spatial management schema, which the two parks teams could then consider and hopefully help to implement. The other tranche of work that we wanted to do was to identify the protocols that would go into the collaborative management of all these places by the parks team and Marra people, and ideally over time in collaboration with other government agencies. This meant understanding how decisions were made by both Marra and government systems and considering how these two seemingly incommensurable systems might work most effectively together. Methodologically, our approach was guided by our collective experience. So David and Sean brought their knowledge of people, place and protocol. I brought skills as a data manager, scribe, map maker and general admin warrior. Together we ensured everyone understood the project and we sought their feedback on its approach and goals. And we worked collectively to interpret what was being shared with us. Now, co-design isn't the focus of today's paper, so I won't go into any more detail about methods or co-design, but I am happy to answer questions if anyone is interested. So this is my first time working with Marra people in Marra Country. So I embarked on this knowing I had a lot to learn. So what have I learned? Why is Marra Sea Country important? For those that haven't had the pleasure of being there, Marra Country is in the Gulf of Ontario. Can I see if I can? And so the sea country extent of Marra Country runs from roughly there we go. So this is the Roper River here. So Marra Sea Country sort of runs just north of the Roper mouth, down through the Limon Bight. This is the Limon River, and down to Wadawada or Rosie Creek, where it meets up with Yanua Sea Country. There's also Humangoni, Beatrice Island, and Goralalinia or Maria Island, are places that people might have heard of. There are many songlines or kujiga which travel through Marra Sea Country. These songlines lay out the truth and the law for Marra Country. Through the travels and actions of these ancestral figures, the ecological, spiritual and social identity of Marra Country was and continues to come into being. The sea, as for the land, is full of power and meaning. The early colonial history of the Gulf was particularly violent. Early cattle drovers, settlers and police all contributed to the death and displacement of Marra people. Marra Country was on the cattle run pushed in from Queensland in the early colonial period, through which most of the cattle which would populate the exploding pastoral landscape of the Northern Territory arrived. With them, of course, were disease, rifles, and competition for precious water sources. Marra's neighbours, the Willingara, had all been killed by 1901. Today, there are no major communities on Marra Country, and most Marra people live in Borroloola, Lukor, Minyeri, and Numbua. Many do not get a chance to regularly visit their country, although have grown up doing so, so they have strong childhood memories of living on and visiting their country. When speaking about country, Marra people point to its kujaga, its sacred sites, its hunting and camping grounds, its animals, and its habitats. In Western conservation terms, we can also describe Marra Sea Country as being ecologically significant. Extensive seagrass beds are home to globally significant populations of turtles and dugongs, and Marra waters have a high biodiversity of fish species, and they do include some of the territory's most productive mud crab and barramundi fishing grounds. And the salt pans of Marra Country also play a critical role in the life cycle of prawns, helping to support a significant commercial prawn fishery in the Gulf. There are 3 Marra Sea Country clans: Budal, Mumballi, and Murungun. Kujaga, clans, and country are consubstantial. It is this collective meaning which defines the identity of people and places and establishes the law. From this derives the protocols around what behaviour is appropriate in a given place and who should be involved in making decisions about it. Appropriate behaviour may include protocols such as the avoidance of dangerous sacred sites, but it can also include protocols such as how food or other resources may be used. What as Westerners we might call ecological values are part of the collective creative spirit of the law. As the ancestors travelled, sang and created the country and its law, the estates of the clans affiliated with each ancestor also came into being. Mingaringi and Jungai, connected through father and mother's sides, worked together to look after the country. Often Dalayan are also called upon as well, being connected through their mother's mother. During a recent workshop, senior knowledge holder Winston Thompson called these the 3 musketeers. They must work together to make all important decisions. The musketeers do, however, call on others to be involved. Who is called upon depends on the decision at hand. It may involve specific senior cultural authorities who hold particular songlines, or it might involve particular family or clan groups. Sometimes it's the wider Marra community that need to be brought together. There are times when men or women play particular roles, and times when young people need to get involved. Given the diasporic nature of the contemporary Marra community, maintaining strong lines of communication across the family groups and across communities is particularly important for Marra to achieve strong, effective, and culturally appropriate governance. And Marra have recently established the Namulcha Aboriginal Corporation to, amongst other things, assist in ensuring strong cultural decision-making, including to help external agencies engage with Marra and their law in a culturally appropriate way. So for Marra, the land and sea are indivisible parts of country, but from a statutory point of view, the picture is quite different. Marra Sea Country today is intersected by the 2 marine parks, each of which has different legislative and administrative frameworks. In addition, separate legislation is used to regulate fish and aquatic species. Prawns are managed separately by the Commonwealth. Other wildlife and parks and reserves, heritage places, sacred sites, land and sea rights, coastal development, water extraction, mining, etc. Navigating this legal complexity, as well as the departmental and administrative processes that go with them, can create significant challenges. I'm only going to canvass a couple of pieces of legislation today in order to try and keep the story as straight as possible, but hopefully this will be enough to get a taste of the complexity that Marra and other First Nations groups contend with. All right, everyone take a deep breath. This is the bit where we go into the legislation for those who aren't legally oriented. Okay, so the Fisheries Act. The Northern Territory Fisheries Act provides for the regulation, conservation and management of fisheries and fishery resources as to maintain their sustainable utilisation. Regulations and management plans, which are additional subordinate legal tools, and the Act is administered by the Northern Territory Government's fisheries team. So currently they're situated in the Department of Agriculture and Fisheries. Commercial and recreational fishing are both regulated through this framework, as well as guided fishing, and Aboriginal subsistence fishing rights are protected under the Act. So each fishery, and I've listed the individual managed fisheries that operate in the territories, each fishery is managed through individual sets of controls, and risk assessments are undertaken using scientific data and expert elicitation. And various metrics are used to track the health of individual stocks, and then thresholds in those metrics are determined, which can trigger predefined management interventions which aim to ensure that the long-term sustainability of that stock is maintained. The commercial fisheries that have the most significant overlap with spatial overlap, Marra interests, are the mud crab and barramundi fisheries, which operate quite close inshore. And there's also significant spatial overlap with recreational fishing sector. The main mechanisms through which Aboriginal people can have input into fisheries management frameworks is through management advisory committees or MACs. And these can be set up in relation to a specific fishery and include one nominee from each of the coastal land councils who sit alongside experts from other stakeholder groups. Okay, Parks and Wildlife Act. So this is the Territory Parks and Wildlife Conservation Act establishes parks and reserves and deals with conservation and sustainable use of wildlife. It also has regulations and management plans and bylaws as statutory mechanisms. So the Limmen Bight Marine Park Plan, for example, is a statutory tool. The Act is administered by the Parks and Wildlife Commission of the Northern Territory, but importantly, fish and aquatic resources are excluded from the definition of wildlife under this Act. So fish, crabs, etc. are managed under the Fisheries Act, but all other wildlife, generally speaking, comes under this one. So this is the legislation that establishes the Limmen Bight Marine Park, and the Act does have provisions for joint management, although the Limmen Bight Marine Park is not jointly managed, and the governance arrangements for that marine park are still being worked through. There's only one other significant marine park in the Northern Territory, and that's on the Coburg Peninsula, but that has its own piece of legislation and so its own governance arrangements. Although the Parks and Wildlife bylaws do provide for the regulation of fishing within parks and reserves, the Fisheries Act is what I believe is called superior legislation, which I understand to mean that when there's an inconsistency between the two acts, the Fisheries Act applies. So in practice, what that means is that any regulation of fishing activities within parks or reserves needs to be reciprocally enacted through the Fisheries Act mechanisms to be enforceable. My understanding is that this hasn't occurred to date, but the two departments are working quite hard to develop interagency processes necessary to support this. And again, there might be people who can clarify, explain the nuance behind this, but my understanding is that some of the key challenges include the way the two departments use different methods to assess risk and have different approaches to the application of spatial management tools. Sacred sites. So the Northern Territory Aboriginal Sacred Sites Act provides for the protection of sacred sites in the Northern Territory, and it's administered by the Aboriginal Areas Protection Authority, or ARPA. So ARPA maintains a register of sacred sites, and sites are protected regardless of whether they're documented on this register. And the register is quite impressive. It contains over 14,000 recorded and registered sites, but it is important to note that a substantial portion of sites remain unrecorded at this time. Under this Act, there are offences around entering and remaining on a sacred site, undertaking works within a sacred site, desecration of a sacred site, and contravention of the conditions of an authority certificate. So authority certificates are legal documents which set out the location and extent of sacred site, well, with restricted work areas, but within a defined area. So what happens is an applicant sets out an area in which they propose to work and the type of work that they're going to undertake, and the authority certificate provides a set of conditions which, if we adhere to, mean that those works can proceed without impact on the sacred site. The costs associated with issuing an authority certificate are generally cost recovered and sometimes can be quite expensive, but an authority certificate is the only way to obtain legal certainty about the ways in which an activity can be undertaken without intruding on any sacred sites, impacting on sacred sites. Okay, Land Rights Act and Aboriginal Lands Act. So probably everybody's heard of the Land Rights Act. ALRA is Commonwealth legislation which operates specifically in the Northern Territory and provides for the granting of traditional Aboriginal land in the Northern Territory. Under ALRA, permission is required to enter onto Aboriginal land, and the Aboriginal Lands Act is Northern Territory legislation which sets out how that permission is granted and establishes the permit system. Land councils perform key functions in relation to the administration of both of these acts, with the coastal land councils being the Northern Land Council, the Tiwi Land Council and the Anandali Land Council. So ALRA applies to the mean low water mark, meaning that the intertidal zone adjacent to put a map of Marra Country. So this is the Marra Land Trust here. So this intertidal zone, so the Marra Land Trust finishes at the low water mark, meaning that the intertidal zone there is part of that land trust. But under ALRA, traditional owners can determine who can access that area, but it's the Fisheries Act that determines how marine resources that are within that area might be utilised. The rest of the terrestrial portion of Marra Country is largely pastoral property and a terrestrial national park. So both of those tenures finish at high water mark. So that meaning that those intertidal zones are now able to be the subject of land claims, and it's probable that over the coming years those intertidal zones will become Aboriginal land and the beds and banks of some rivers systems in our country as well. So the Northern Land Council has introduced a recreational fishing permit system for access to those ALRA waters, but has not yet had the chance for detailed consultations in most regions regarding refined access instructions, for example, around sacred sites. Commercial access to ALRA areas is normally managed through Section 19 agreements, and at present, interim commercial fishing arrangements are in place until those agreements can be considered by traditional owners. Okay, EPBC Act, and I think this is my last one. Now, the EPBC Act is gargantuan. I'm not going to go into a lot of detail. I just want to flag here that this is the legislation under which the Commonwealth Marine Parks are established. The Marine Parks Division of Parks Australia implements the management of these marine parks on behalf of national parks. Now, some elements of management are administered by a network team, so the North Network team, who are based in Hobart, will be online today, whilst other elements are administered by national teams which deal with specific issues, for example, compliance and research. There are no ranger teams run by the Commonwealth to manage network of Australian marine parks, but instead work is undertaken in partnership with other agencies, so state and territory agencies, federal agencies, Indigenous ranger groups and research institutions like AIMS and CDU. So all of the other legislation that I've spoken about all applies to territory waters, so that extends to the 3 nautical mile or about 5 kilometres from the coast, seaward of the coast. And I guess I just want to point to the fact, sacred sites, heritage matters, conservation issues are all managed and regulated differently in territory and Commonwealth waters. Right. So that's just some of the legislation, and there is plenty more, and there is quite a lot that you can say about each of those pieces of legislation and the administrative processes associated with them. But as a general observation, you can see that each tends to silo different kinds of values about country and triggers different management frameworks, which for Aboriginal people for whom country is an integrated whole, you can perhaps start to imagine some of the challenges that they face in navigating this. So I'll give a couple of illustrative examples of the challenges, but I don't really want to focus on the problems, so I'd like to do that quickly and then come back to some Marra-led solutions. Okay, I'm going to talk briefly about fishers who enter into sacred sites. So intrusions into sacred sites by recreational and commercial fishers has been a concern of traditional owners across the coastline for many decades. In theory, it is an offence to enter, remain or undertake works on a sacred site, but there are certain defences which mean that few site intrusions in the marine space are able to result in successful prosecution. For example, in most cases, it has to be established that the person knew that an area was a sacred site. And they're all criminal offences too, so the evidentiary threshold is quite high for these prosecutions. For these and other reasons, the risk of prosecution are overall relatively low. On the other hand, the cost to commercial operators to obtain an authority certificate and then to not fish in any identified sacred site areas can potentially be quite high. Whilst there are provisions in the fisheries legislation to ensure that commercial operators do not have a relevant criminal background which should exclude them from a fishery, site-related convictions are not considered relevant in that way. There's no reciprocal recognition between the Sacred Sites Act and the Fisheries legislation, and neither act requires commercial fishers to seek an authority certificate or otherwise ascertain the location and extent of sacred sites within the area they fish. There may be some opportunity for requiring fishers to obtain an authority certificate as part of the conditions of a Section 19 agreement, although it's unclear to me if that requirement would just be restricted to outer waters to which that Section 19 applied, and if so, that's a very small portion of people's sea country estates. Anecdotally, my experience is that recreational fishers are largely unaware of the Sacred Sites Act and its provisions, and my understanding is that no recreational fisher has been prosecuted for a site-related offence. And if there's anyone from ARPA online, they can perhaps just fact-check me on that one. So fishing permits, although issued under the land rights legislation rather than sacred sites legislation, might be a pathway for ensuring rec fishers are aware of those obligations around sacred site avoidance. But again, that's most likely to be useful in outer waters, which is only part of the sea country estates of the Northern Territory. One innovative approach that I'd like to flag was taken during the resolution of the Can Be Maintained. In this case, and again, please correct me if I get this not quite right, but in this case, I believe the Northern Territory Government applied for an authority certificate on behalf of the recreational fishing public, which resulted in a sacred site survey of intertidal sites from roughly Wagga Beach to Dundee, including parts of Byron Harbour. So similar certificates may form part of future agreements to resolve intertidal access issues in other parts of the Northern Territory, and if applied to all of sea country and not just the intertidal zone, could provide quite significant outcomes for sacred site custodians, as well as provide legal certainty to the commercial and recreational fishing communities. The substantial cost of these exercises is, however, likely to prohibit this as an option in areas other than the most heavily fished sections of the Northern Territory coast. There is occasionally collaboration between fisheries and ARPA in terms of reporting and documenting alleged site offences, but by and large, each agency is restricted to their statutory domain, and for administrative resourcing and other reasons, significant interagency collaboration has not really occurred to date. Other fishing impacts. So sacred sites were the biggest concern that Marra people raised in relation to protecting sea country places, and it's my personal experience that's pretty consistent across other parts of the coast. But there are a number of other issues that people raise in relation to fishing that were raised during the consultation. So these include issues around overfishing, lack of benefits to the Marra community from that fishing activity, rubbish, marine debris and discarded fishing gear, lack of information about or control over about fishing activity in their country, poor compliance outcomes and privacy and food security issues. So these bring up a whole bunch of different statutory arrangements, and I'll only sort of touch on a couple of these now. So rules about fishing are set by the Fisheries Act, etc. During our consultations, though, Marra people expressed a view that these management arrangements did not respond particularly well to the specific needs of their country. And this is understandable. You know, the Northern Fisheries team are generally required to manage fisheries at a NT-wide spatial scale, which creates challenges in designing management interventions at the scale of Marra or other people's sea country. Some of the fisheries management interventions that Marra people said they would like to see in their country include the tweaking of barramundi closure lines. Let's see if I can find the map. So on this map, the red lines are barramundi closure lines. So that's the gill nets cannot be set inland from those lines. So people wanted to tweak some of those. They wanted to restrict the use of commercial fishing gear in turtle and dugong hotspots, and so that's mostly along a huge seagrass bed that extends between Yumunguni down to Wada Wada. They would like to see the introduction of a closed season for commercial crabbing, and that's because they are already observing mud crabs having a stress response to increased sea temperatures. And fishing restrictions in some small areas that, in order to protect Marra privacy and food security. So Marra people have no rights to negotiate any community benefit or to control access to their sea country beyond outer waters. Over time, permits and or long-term access arrangements for rec fishers and Section 19 for commercial fishers should allow some Marra concerns about fishing to be addressed, although, as I've said, those outer waters are only a very small portion of Marra Sea Country. And there remains a substantial amount of legal uncertainty about the spatial extent of that intertidal zone, so it's not really clear the exact spatial footprint to which those rights might apply. Originally, the marine park was seen as a positive pathway to addressing some of Marra's concerns around fishing, although it is now understood that this will require interagency coordination that extends beyond their partnership with the parks team. So the discussions between parks and fisheries are seen in a really positive light, but these discussions will take time. So it's unclear for Marra at the moment what the outcomes for their country will be. And one little final example is cumulative impacts and integrated management. So there is an iron ore mine on Marra Country up on the Towns River, and there is substantial agricultural development and water extraction plan for the Rope River. Climate change has already caused significant mangrove diebacks and is likely to have impacts over time. So in theory, each of these processes, well, in practice, such pressures are assessed by the regulatory processes which, for example, determine water allocations or mining approvals. But these assessments occur independently and rarely take an integrated cumulative stress approach. They're also separate from the fisheries and conservation risk assessment processes and the deployment of protective mechanisms under the Parks and Fisheries Acts. And within each of these administrative processes, Marra express a view that they feel they have only a small, if any, voice. So overall, they express a lack of confidence that those processes will adequately safeguard their interests. And understanding and dealing with all of those multiple processes and pathways is also highly challenging for people. So what are the solutions? Well, Marra's response to this structural complexity was to undertake their own planning process to consider exactly what it was that they want from each of those legislative pathways. So as I mentioned, when we presented the resources of the ARC project to them, they prioritised using a culturally appropriate consultation method to map Marra Sea Country values and concerns, and they wanted to understand the governance frameworks which apply to their sea country and how those systems might be coordinated to ensure a strong Marra-led decision-making framework. So collectively, I'm going to refer to those tasks as sea country planning today. So in identifying specific places and protective mechanisms that those places require, Marra are enabled to present a clear and concise picture to agencies about how they would like those processes to be applied to the protection of specific locations. So what does it mean? So this is a bit of a visual seeing where, so Marra have their healthy country plan, they have their draft zoning scheme, and they're trying to work collaboratively with the parks teams who, the idea is then those parks teams use their own management frameworks and statutory tools to support the implementation of that Marra-led approach. But, there is no shortcut. Marine planning is messy. So this is that Marra design zoning scheme with all the tenure boundaries thrown back on top. Well-designed marine spatial management schemes are hard to develop at the best of times, given data gaps and conflicting stakeholder interests. In the Northern Territory context, where we face the complexity involved in simultaneously navigating two systems of law, the methodological challenges are significant. It's not a matter of simply adding consultation to current approaches, but finding new ways to better accommodate Indigenous values and law within traditional risk assessment and other planning processes, and as well as addressing interagency gaps and silos. We are seeing signs that some agencies are being very innovative in this space and indeed are very proactive. And we suggest that supporting sea country planning is an effective and ethical way for such agencies to approach this challenge in a solution-focused way. Government agencies do not usually have the expertise, time or financial resources to do high-quality ground-up work on their own. And importantly, First Nations knowledge is the intellectual property of First Nations groups. So ethical engagement involves giving groups the space to discuss their knowledge internally, develop their own solutions, and decide how and on what terms they want to share relevant parts of their knowledge systems to support cross-cultural understanding and partnerships. Projects like ours allow groups to do their own value assessments using methods that are culturally appropriate and which genuinely understand and engage with the identity and law that country holds. This kind of work requires specialist expertise and experience, and it is from within First Nations groups that this expertise is located. There is a role for external expertise, and I hope that in this case, mine has contributed to the outcomes of the project, but such collaborations must be through projects that are First Nations led, rather than those driven by external agencies, including government and research institutions like my own. Agencies have their own methods and processes to underpin decision-making, for example, to register a sacred site, assess the sustainability of a fish stock, or identify habitat. Similarly, First Nations groups have their own approaches to ensuring that the right people are engaged and speaking for the right places. Models of collaboration which allow these processes to run their own course but still come together in an efficient, equitable and ethical way are of significant benefit to all parties. So far, we've hoped that the approach we are taking to sea country planning, it seems to offer such a pathway. It's a model that works to people's strengths and fosters collaboration rather than taking a deficit or adversarial approach. And whilst I haven't delved into it today, when done well, it really does. There are methods that can ensure the sharing of knowledge in ways that allows First Nations and scientific knowledge to both be fully utilised to assess impacts, risk and management opportunities. So just as traditional owners remain accountable to the systems of governance and law from which their authority arises, so too are government agencies and statutory authorities bound to their legislative domains. Both systems of law govern how and in what circumstances decisions can be made. Bringing these systems together is not an easy task. The approach we're taking to sea country planning recognises the dual authorities of traditional owners and government and seeks to enable both sides to work collaboratively together to fulfil their responsibilities. We have a lot of work to go, but we are excited about the partnerships that are starting to take shape and the opportunities this presents for Marra and their sea country. As Namolcha say, together, stronger. What do I do now, Lani?
So we'll take some questions from the room.
Any? Anyone want to ask anything or as importantly correct anything if I've gotten details wrong? Yeah, Tash.
Thanks very much, Jackie. It's great to see that work coming together around policy coherence, trying to link up all the different policies and values and systems together for better management of sea country. I was thinking about the sort of implementation going forward. Obviously, we've been working together to create that collaborative opportunity and space for the sea country zoning and planning. How do you see it going forward in terms of the actual implementation, and what are the opportunities for setting up some policy and governance coherence over the medium to long term?
That's a pretty big question. So there's lots of parts to that. I don't know that I could answer that in full. I think, this ARC, I'll stick to the parts that are mine to speak for. So the ARC is a collaboration with the two parks departments, and they are really determined to look for ways to navigate the policy and practical challenges in working better with First Nations groups whose estates their parks overlap. And they also express that the more they can collaborate with other agencies and authorities, the more effective they can be in that task. So that's definitely on the radar. I guess some of those other implementation elements are probably not mine to comment on. Like, I think I would prefer for David and Sean or Marra people to speak more to that vision than me try and represent it on their behalf. Yeah, but I think there is opportunity. I think it's a complex space for traditional owners to understand and navigate all these statutory processes and policies, but it's also really complex for different agencies to engage with it too. So hopefully this sort of work is creating some middle ground where people can come from those, like recognising the genuine authority and knowledge that each bring to that table and can work through some of that stuff together. But it'll be a slow chip in the way thing. Nothing happens overnight. Does that address your question, or?
For now, yeah.
We can have like a full, hour-long tracking out of that.
It's an interesting area, and from a researcher's perspective,
Yeah.
drawing on, what happens in other parts of the world. I mean, this is not a unique situation. It happens all over Australia and all over the world, and so interesting to sort of reflect on how other places and people are trying to navigate some of these big challenges.
Yeah, I agree. That would be really. I'd love to be able to allocate some time to work them through some of that stuff. That would be useful.
Thanks.
We have one question online, Jackie.
Yeah. Might bring it up.
Okay, what is the feeling of anti-government organisations to allow compliance issues to be dealt with directly by community rangers? This is an important desire and request of Kimberley Groups. That's from Marshall Debshinsky.
Can I bring that up here so I can?
You can on those Q&A sections.
Martial. Okay. Hi, Martial. What is the feeling of military government organisations to allow compliance issues to be addressed? So there are currently provisions, I understand, in both the Fisheries Act and the Parks and Wildlife Conservation Act that do allow for the delegation of certain authorities under those acts to Indigenous rangers, and there are existing and emerging pathways for rangers in the Territory to undertake the training, I guess, the accreditation to be authorised under those pathways. So I don't know that I can speak to all the intricacies of that and the challenges that those ranger groups and departments have had to face in getting systems up and running. But yes, it is definitely a key desire from people on the ground, and they do seek over time to be able to increase their role as delegated officers under various legislative processes. And I'm sure would be quite excited if they have powers under some of the other legislation that I spoke to today, but I think the parks and fisheries ones are the only ones that exist at the moment. Does that answer your question, Marcial? Sam?
Thanks, Jackie. I was struck by your comment that the Marra community is kind of diasporic and located in so many different places, and also that all the different parties to this work are also quite diasporic. They're located in Canberra or Tasmania or Darwin or wherever. And I just wondered if you could speak to kind of the methodology in working together when people are so spread out, and like what it takes to do work that people can buy into and feel invested in when there's all that.
Yeah, and I didn't go into the methods part because that is like another one of, I had to sort of box all these different things and say, sorry, I can't deal with it today, but that is another one. And what constitutes a strong and robust methodology for engaging with Marra people may not apply in the same way for Yanyuwa or Andalaka or wherever else you want to go. So that's not really an answer to your question. So, I mean, I guess for us in this particular setting, what we decided to do is to first visit people in their home communities so that we could engage with people on a, small groups or one-on-one. And that was so that we could really ensure free, prior and informed consent from people by working with them in small groups, so we could really explain to them what the project was about, what knowledge we were asking them to contribute and why and what we're going to do with it. It also enabled people to speak to their own authority and for specific places and ask us questions. And so, there was a lot of times, for example, where people go, well, I can't make that, I can't speak about that on my own. I need to have someone else there. And so in this particular case, we had to navigate the challenge of geography. So we would at times call people up on the phone, or we'll go, okay, well, we'll take what you've said to them and we'll feedback what they say to you. There's another way of doing it. And we did structure in from the start a combination of these, we called them our roadshows, to go and visit people, and committed to every time that we saw someone, we said, look, you know, our big thing will be to bring everyone back together so that we can speak to you guys as a group, and you can all collectively hear the kinds of issues that you are raising, and that you can make some decisions as a group. So yeah, and the gender thing as well, you know, sometimes we have to speak to men and women together, sometimes separately. We had to navigate, you know, whether David or Sean or myself might ask the questions, and how the questions were asked all had to be responsive to those cultural protocols. But again, you know, how that plays out, but I guess you deal with similar themes every time you do a body of work like this, but they play out in different ways, and you have to be astute to that and able to accommodate. Does that address what you?
Yeah, it just sounds like an enormous amount of resources involved in doing kind of good work, which I think is just a point of reflection for like anybody who's trying to do similar things in the future, you know?
Yeah.
What it takes to.
It is, yeah.
Yeah.
Chip away slowly. Slow and steady wins the race.
One more question online from Sunil. With respect to tweaking the Marra's closure zones, isn't gill net fishing soon to be banned in the NT?
I'm not a minister, so I'm not privy to the decisions that the government will make. They did make that promise prior to the election, I understand. I don't know the mechanics of that. I guess the consultation work we undertook was prior to any election commitments. And so I can only comment on the concerns. You know, I guess when we're talking to people, they're talking about the historic concerns that they've had. So, yeah, I can't. It's a complex issue whether the removing of gill nets would address all of people's concerns. And I'm happy, Sunil or others, to have a conversation about that. But yes, the government did commit to that over a 4-year period, I believe.
We'll wrap up.
Yeah, does anyone else want to ask anything? Oh,
You have one question. How did the project start? Did you already have a relationship with the Marra, or was that the beginning?
no, I had just come back from maternity leave and was looking in the barrel having no research funding. So I went out to all the people who I'd worked with over the years and said, what next? And so from that emerged this ARC proposal for Indigenous-led Sea Country management. And this is only one of the component projects. And it was actually initiated, this was the suggestion of the 2 parks teams who at that stage I had early relationships with, and they said, look, we really like some think tanking support with this stuff. Yeah, and I remember when I was fairly heavily pregnant and trying to cobble together this, because I was about to go on maternity leave again, this application, and being in the parks office and on this really terrible phone line where they put poor old David and Sean on the phone, and the internet was dropping out. It was before Starlinks were around, and I'm just like, hi, you don't know who I am or what my background is, but can I put in this application on our collective behalf? You know, it was the epitome of where you can go wrong in building relationships with people, but they had the grace to allow me to put that component project in that the parks teams had proposed, and they already had existing relationships with those parks teams as well. So that led to the trust that allowed them to trust Parks's assessment of me. And then, yeah, when the money came through, you know, I was very clear that if we ever got the money, that I would come back and do some proper co-design, and that I was aware of the limitations of my relationships and knowledge in that area. So that was my way of trying to not want to do a whole co-design project when we didn't know if we were going to get the money, but to make sure that there was a very clear space allocated in that project to ensure that they would be the ones that guided how this would unravel if we got the money. So, yeah. Does it?
Yeah.
Following on from that, I presume in your ARC application, you put your first step was to do that.
Well, we don't get a lot of space to explain a lot of the details, unfortunately, but I guess we managed it by phrasing things at a fairly high level, so that there was a lot of different ways one could tackle that issue. Yeah, well, you know, we did what we said we were going to do, but we made sure that it was responsive to Marra priorities rather than just simply going out with some predefined agendas. And does that?
I think we'll round up there. Thank you, Jackie. That's our last webinar for the year, everyone. So thank you, Jackie. I really appreciate it. Okay.
Awesome, thank you.